You're listening to Workplace Perspective, an employment law podcast presented by SAFFIRE Legal. Workplace Perspective is a regular podcast series for employers and employees focusing on education, training, and the law to help organizations of all sizes develop and maintain successful workplace relationships. The opinions expressed by guests on Workplace Perspective do not necessarily reflect those of SAFFIRE Legal or its attorneys and should not be considered legal advice. And now, here's your host, founder and principal attorney at SAFFIRE Legal, Teresa McQueen.
Thank you, James, and welcome everyone to Workplace Perspective, where we are striving to raise the bar at workplaces everywhere. Today, we're talking with plaintiff's attorney Kevin Ruf. Kevin is a partner at the LA firm of Glancy, Prongay Murryay, and has the distinction of having successfully argued the Lee v. Dynamex case before the California Supreme Court. The Dynamex case, a court opinion, was published in 2018 and created shockwaves across California because it altered long-standing California laws regarding the classification of independent contractors and established the new ABC classification test. Kevin's going to be sharing his insights into the Dynamex case and his thoughts on AB 5, the California legislation that was enacted in 2019, codifying, Dynamex and its ABC test. It's going to be a great show. Don't go away. We'll be right back.
The opinions expressed by guests on Workplace Perspective do not necessarily reflect those of SAFFIRE Legal or its attorneys and should not be considered legal advice. You're listening to Workplace Perspective, an employment law podcast presented by SAFFIRE Legal.
Welcome back to our listeners, and welcome to Workplace Perspective, Kevin Ruf.
Thank you. Thanks for having me.
Kevin, I'm so excited to have you on. I've followed this case and AB 5, and I'm so excited to talk with you. But before we get started, I want to make sure that you tell our listeners a little bit about you and what you do.
Well, as you said, we mostly do plaintiffs, class action stuff. I'm actually kind of a generalist in that area. We do consumer stuff. We do a lot of security stuff. And then over the years, it's kind of become sort of a little side area that I've been mostly involved in, which is the labor class action stuff. And along with, by the way, very impressive pronouncing Dynamex properly. That was impressive. Along with Dynamex, I also argued the Smith versus L'Oreal case, which was about waiting time penalties and the definition of discharge in the Supreme Court of California. So I've been really lucky. I've gotten cases into the Supreme Court, kind of, as you can imagine, you never know where things are going to end up. And I've just been lucky to be there twice.
Yeah, it is. I mean, attorneys go their whole careers and never get to argue at that level. So to be able to do it twice is really amazing and not bad for a side act, I got to tell you.
Yeah. Well, the funny thing about it is, our firm has had some really interesting cases in the labor area from an appellate perspective, but it's amazing, how many of my friends in the same area of law have made so much more money than we ever have. I'll actually, in that area, a funny little anecdote. When we won the Dynamex decision, it sort of, I guess, not exactly proper to say we won the case. We got a great decision, but the case continued. And it was funny that so many of my friends would call me up and go, "Oh my God, I just settled a case for $30 million. Thanks to your case. Thank you. I just settled a case for $50 million. Thanks to your case." And then, by the way, how's that case going? Well, we've been litigating it for 15 years. And, we did finally settle it. And it, settled for $6.25 million. So, which was great. And the drivers got a great result. But in terms of, the pure business part of it, you can imagine multiple lawyers on that case, 15 years, $6.25 million, was not an amazingly profitable case, but it was amazing to work on. I would never, trade it for sure.
Yeah, I don't think a lot of people realize that the case was originally filed, what was it, 2005?
I rounded up. I mean, I think it was 2006 it was first filed. We actually had filed, my firm had filed a case, unbeknownst to us, on top of another firm, Mark Pope and Pope, Berger and Williams. They had already been litigating it, for a couple of years when we filed. And then when we jumped on top of it, they had just come back from the appellate court on a bad decision on class certification. And then, the rest is history. We litigated it from there and then got close to trial and then found ourselves back in the appellate court and then won there. And then, of course, Dynamex petitioned the Supreme Court, and they said, yeah, we'll look at that.
Well, it's amazing. It's just for the fact of it's just whether it's right, wrong, or indifferent, whatever side you come down on, it's still pretty amazing. To change the significance of the case across California has just been amazing.
Yeah.
Do me a favor. Tell us some interesting stuff about the case, just to begin with. Maybe a little bit of background. We're coming up on it, which it's so short a time. I want to talk to you for such a long time, and we can't. But I want to hear a little bit of the background on the case, a little bit of insight into the case from your perspective.
Yeah, I'll try to give an executive summary. There's so much, of course, you can talk about with 15 years. But, what would be interesting, especially if lawyers are out there listening, is that it was one of those cases that kept on sort of, unveiling new aspects. And the one that really drove the Supreme Court case was this question of individualized issues that we so often face in class actions, and the fact that our trial judge, who'd already denied certification years earlier, had kind of made it clear that he was having some concerns about different ways that different drivers had been treated by the company, and feeling like kind of gave us a preview that he was going to have issues with certification because of these so-called individualized issues. And my partner in crime on the case, not my partner in my firm, but a partner at a different firm at Pope, Berger Williams in San Diego, Mark Pope, is an absolutely stellar lawyer, one of the great guys I've ever met in law. He'd been looking at Martinez v. Combs, which was a recent Supreme Court decision, and that had talked about how the wage orders under California law have these alternative definitions of what it is to employ somebody. And one of those was really broad. It was to suffer or permit the provision of service, right? So, boy, that's about as broad as you can imagine. Who's going to be left out if you merely have to allow somebody to provide you a service and now you're employing them? And, of course, that's kind of how the defense saw that all along in our case. We then said, well, that is an alternative definition. Let's ask the court to certify at least based on that, because every single driver, was treated the same with respect to suffer or permit. And to our surprise, the trial court said, oh, yeah, that works. Suffer or permit. Sounds good. And then we ended up in the appellate court, and I was always a naysayer. I argued both cases, and so the first one was the appellate court, and I kept on saying to our guys, they're going to ask me these hard questions. They're going to say, how is suffer or permit any kind of standard at all? I mean, when I walk into a barber shop, aren't I suffer and permitting that person to cut my hair, and how am I not then their employer? And I imagined all this stuff, and the reality was we showed up in the appellate court, and the appellate court was sort of sanguine about the whole thing and kind of accused the other side of henny penny, the sky is falling, but no, this is okay. This is a standard, suffer permit. So, they, of course, on the other side immediately asked the Supreme Court to review it and said, this is no standard at all. This can't be. And the Supreme Court takes it. And to be honest, I assumed that the Supreme Court would have some issues with a broad standard like suffer or permit. And, I kept on asking we had a great brain trust. We had people, Michael Rubin at Altshuler Burzon got involved as an amici, and Monique, I think of her last name, was another really vital part of our group. And, I kept on asking, well, how am I going to answer that hard question of what exactly does this mean in the real world to real people with real jobs? I mean, you can imagine that Sapphire does a lot of consulting. You can imagine, what your, well, you probably already know. I mean, they're already, having issues, but at least, the ABC test came along. And so the funny thing was we never, on our side, actually identified ABC as how we would get to define the sufferer permit prong. And we were about 2 months away from oral argument, and we got this request for letter briefing. And effectively, the Supreme Court said, when you guys say that we should adopt this sufferer permit standard for what it is to employ, are you really talking about something like the ABC test? And we all looked at each other and said, yeah, of course that's what we're
of course.
Sure.
Yeah, that works.
Let me look that up really quickly. And yes, that is exactly what we're saying. But, the truth was that ABC was a kind of decent proxy for sufferer permit in the sense that sufferer permit was really intended to be a really broad standard that would wrap most service arrangements into employment in California. I mean, that really does seem to have been, the intention back in the day, in the turn of the century in the 1900s when these wage orders were promulgated. So, it was, I think without ABC, I just can't imagine how we could have won the case. And I always knew that we would have to come up with something practical as a way of defining employment, much more so than the broad sufferer permit. But I think the Supreme Court, for its part, saw what we described as kind of a sort of wild, wild west out there, where companies were using independent contractors in such broadly different ways to the point where some companies were trying to compete with other companies in the same industry, where one company would have employees and the other would have effectively a staff or a workforce of independent contractors, and they couldn't compete. And I think the Supreme Court said this was never intended, independent contracting was never intended to be a substitute for a workforce. I mean, the idea was that these would be, individualized, unique situations, not, hey, if I decide my whole workforce is independent contractors, boy, that saves me a lot of money. And by the way, in the old adage of bad facts, bad law, I mean, at least from I think it's great law, but from the perspective of obviously employers, it puts new burdens on them. But, the truth was, in our case, the facts were really bad. The facts were that we had an entire workforce of truckers who, at the end of 2003, I believe, were all employees, and then on January 1st, they became independent contractors. Suddenly, they're entrepreneurs, and of course, the court found that to be not, didn't seem very substantial as a basis to classify people.
Well, I wouldn't think so. Well, and that was one of the interesting things I thought. There's a lot of things I thought were interesting about the case, but one of them being this idea, as I was reading through, that the term independent contractor really has been hijacked. That concept really has been hijacked because it doesn't mean what it used to mean. So even in the case, it talks about it being applied, to an individual worker, right, who has independently made the decision to go into business. And I love the way they phrase that, because that is not how it is now. Anytime a client calls and asks about, prior to all this, right, it was all about, well, I'm going to hire this person as an independent contractor, and I need to tell them to go incorporate or do an LLC, right?
You know what? That is
no. The idea is you're not going to tell them to go into business so that they can work for you.
That's a super insightful point you're making, and actually, frankly, something I forgot to mention in terms of those bad facts, because I think the court saw a lot of significance in that. That was something I actually brought up in the argument, which was that the lack of an organic creation of the independent contractor relationship has got to be viewed with suspicion, right? Just like you're saying, I mean, if you've got a person who's already created a business and comes to you as the hirer as an independent contractor, that's so different than when, like you just said, you say to somebody, I'd love to hire you, but you'll have to be an independent contractor, so here's what you'll have to do. here's a package, and go out and create yourself, and it's just not organic. And the truth of the matter is, those situations, I think, give rise to a lot of skepticism by a court as to the validity of the true independent nature of the work.
Yeah, absolutely. I agree. We are, if you can believe, we're running out of time, and I want to get your thoughts on. I want to get your thoughts on AB5. And in preparing for this show, I was kind of going back and looking at things, and I thought it was really interesting that this idea that the case ends with concluding that statement by the court that they felt that their decision in the Dynamex case was going to provide greater clarity and consistency, less opportunity for manipulation, and a test or standard that requires consideration that as opposed to a test that requires all this weighing of the factors and different factors on a case-by-case basis. And I was really excited because I thought it did that as well. I think when you and I were preparing for the show, I mentioned to you that I thought it was great that finally, from a practitioner standpoint, you could give a more definitive answer when a client came to you and said, or an employee came to you and said, am I an independent contractor, or is this person an independent contractor? Because it gave clarity. Yep. ABC, yes or no. Yep. Great examples, in the case and all that. But then, of course, that lasted almost less than a year because, dun, 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 there was AB5. So tell me in our last few minutes here, tell me your thoughts on AB5.
Well, I was going to say, I to begin with, I agree with you that at least arguably some, employers could be happy with more structure. And again, that was another thing that the Supreme Court, I think, was looking at, was this idea of, we talked about Borrello and all the factors, and how if you ever go to trial in a Borrello case, you end up handing the jury this pile of stuff, and then you say, okay, some of these are important more than others, like control, but ultimately it's up to you to decide. It's like, what, I don't know. So, AB5, I think, is a well-intended attempt to simply, codify the decision in Dynamex. I think it's designed to be worker-friendly. I think that it needs, it will continue to evolve. I mean, I know a lot of musicians, and I understand that the musicians are finally going to be carved out of it. I think they should have been from the beginning. I mean, to be honest, I think musicians are one of the few areas where I think, probably I and the defense bar would all agree, those people really do kind of meet most of the criteria for being a legitimate independent contractor. They have a specialized skill. They have their own business. They have their own, they bring their instruments literally. I think, there are obviously a lot of carve-outs in AB5. I mean, an interesting aspect of AB5, of course, is that it went, if you're inside baseball, lawyers who do this like we do, you also know it really extended Dynamex in a profound way by extending it to the entire labor code, as opposed to Dynamex itself, which was based on an interpretation of the wage orders. So, we in the Dynamex case itself, after winning, we're still faced with a major question about whether the really most valuable claims we had, which were 2802 claims under the labor code for unreimbursed business expenses. As you can imagine, that's really a big claim for truckers. If that would be determined under the historical Borrello or Dynamex, and to be honest, I think the better argument was going to be that it would have to be under the old standard, because the court had kind of even looked at it in our case and sort of said, well, that's for another day. But overall, the suggestion was that our case was about the wage orders, not the labor code, unless the labor code provision in question was clearly a provision that had arisen from the labor code. So, if it weren't one of those basic, provisions of the labor code like minimum wage that clearly was part of the wage orders back in the day, then you would presumably have to, you could have a trial with two different standards of employment, depending on the claim. So, I think AB5 wanted to just clear the air and, apply the decision, the ABC test, to pretty much all of employment in California, but there are lots of carve-outs for sure. And, I think there's still some questions about retroactivity, and there's obviously some of this sunsets, I believe. There's a 2023 provision sunsetting, and there's some areas that still are explicitly covered by Borrello. So it's it's an area that could occupy some lawyers almost completely, I'm sure.
Yeah, I think so too. I thought that was really interesting about the wage order, and it just sort of became a side issue all of a sudden. A lot of us that were working with it when the case came out, I came to the same conclusion. I think, well, there are two different standards because, clearly talks about the wage orders, but it's interesting how that just sort of got glossed over and it all sort of got lumped in together. Kevin, we have 2 seconds left. I really want to bring you back at some point so we can talk more about this because there's so much to talk about we haven't even touched on. But give us your thoughts, your words of wisdom on the future of the workforce in light of all of this as we wrap up.
Well, I wrote an article in the San Francisco Chronicle, maybe a year ago, and what I believe is that employment relationships need to and should evolve. I'm not somebody saying that, the historical conventional employment is exclusively the way people should be able to arrange their relationships. But I think, I'll add to it, I think COVID-19 has really opened some people's eyes about the extent or not of the, social safety net and how you monetize that. Because if you've got a bunch of people out there who are acting as independent contractors and not paying into a system that provides for unemployment and health care, et cetera, and then suddenly, are essentially on a humanitarian basis in need, I think it's kind of brought some of these issues to the people that predicted this kind of thing, are being, shown to have had a point, and the Supreme Court, by the way, had said in Dynamex that was one of the biggest issues to them was that there was a lack of fairness in how these kinds of basic aspects of safety net were being paid for, and some companies were kind of just giving themselves a pass. So I think they're gonna be something in between. I think there will be something, and maybe that's going to be reflected in that new the initiative that Uber and Lyft are proposing. Which has certain protections, but it's not full blown employment. So we'll see.
Yeah, we didn't even get to talk about that, the app-based driver's regulation. Kevin, I want to thank you so much. That's our show for today. I want to thank you again so much for joining me and sharing your thoughts and your experience with the case with all of our listeners. I really appreciate it.
Teresa, great talking to you. Great job.
Thank you so much. If you want to learn more about Kevin, you can find more about him and his firm on the web at www.glancylaw.com. That's GLANCYLAW.com. You can also connect with Kevin via our website at sapphirelegal.com/podcast. I want to also thank our listeners, My Radio Angels, James and the Knave at Night, and Workplace Perspectives team extraordinaire, engineer producer Paul Roberts, our associate producer Melissa DeLacy, with music provided by the very talented Stephen Versaloni. Thank you all for joining us on Workplace Perspective, and until next time, keep raising the bar.